In this video, I'll explain how to win a construction dispute in Florida without ever stepping foot inside a courtroom. By the end of this video, you'll learn the exact strategies Florida property owners, developers, and contractors use to resolve construction disputes faster, cheaper, and with better outcomes than going to trial. I'm Santiago Cueto, board-certified international business law expert and best-selling author based right here in Miami, Florida. I have spent decades helping businesses navigate complex disputes, and I can tell you this with confidence. Most construction disputes in Florida never need to reach a jury. So let me walk you through exactly how that works. Here is something most people don't realize. Construction litigation in Florida is one of the most slowest and most expensive types of civil litigation. The average construction defect case can take 2 to 4 years to resolve through trial. That is 2 to 4 years of attorney's fees, expert witness costs, depositions, and stress. And the truth is, Florida courts are backlogged. Judges in Miami-Dade County, Broward, and Palm Beach counties are handling enormous caseloads. Your case is one of thousands. That means delays on top of delays. But there is good news. Florida law actually encourages parties to settle construction disputes outside of court. The state has built-in mechanisms designed to keep these cases out of the courtroom. The smart move is to use them. Let me break down the strategies that actually work. The first thing you need to know about is Florida Statute Chapter 558. This is Florida's construction defect pre-suit notice requirement. It applies to nearly every residential commercial construction defect claimed in the state of Florida. Here's how it works. Before you can file a lawsuit for construction defect in Florida, you are required to serve a written notice of claim on the contractor, subcontractor, design professional, or whoever you believe is responsible. That notice must describe the defect in reasonable detail. Once the other side receives your notice, they have a specific window of time to respond. They can offer to inspect the property, they can make a monetary settlement offer, or they can propose to repair the defect themselves, or they can deny the claim entirely. This pre-suit process is powerful because it forces both sides to the table early. It creates a structured negotiation before the meter starts running on full-blown litigation. Many construction disputes in Florida are resolved right here, during the Chapter 558 process without any court involvement at all. The key is getting that initial notice right. A vague or incomplete notice weakens your position from day one. Now let's talk about mediation. This is one of the most effective tools for resolving construction disputes in Florida. In fact, most Florida circuit courts will order mediation before they allow a construction case to go to trial. Mediation is a structured negotiation facilitated by a neutral third party. The mediator does not make a decision for you. Instead, they help both sides find common ground. Why does mediation work so well for construction disputes? Well, because these cases are almost always about money. They're about the cost to repair defective work. They are about unpaid invoices. They're about delays and damages. A skilled mediator can cut through the emotion and help both parties focus on the numbers. I've seen multi-million-dollar construction disputes in South Florida settle in a single day of mediation. Cases that would have taken 3 years in court resolved in 8 hours. The secret to winning mediation is preparation. You need a detailed damages analysis. You need expert reports, and you need a clear presentation of your strongest facts. Walk into that room knowing your number, knowing your walkaway point, and knowing the weaknesses in the other side's position. And speaking of preparation, if this information is helping you, take a second and hit that like button. Subscribe to this channel so you do not miss my next video on Florida business law. It really does help the channel grow. Now here's the strategy that catches a lot of people off guard. Check your construction contract. There's a good chance it contains a mandatory arbitration clause. Arbitration is a private dispute resolution process where one or more arbitrators hears both sides and issues a binding decision. Think of it like a private trial without the courtroom, without the jury, and usually without the years of waiting. In Florida, arbitration clauses in construction contracts are generally enforceable under both the Florida Arbitration Code and the Federal Arbitration Act. If your contract says you must arbitrate, you cannot simply bypass it and file a lawsuit. A Florida court will almost certainly compel you to arbitrate. But here is what matters. Arbitration can actually work in your favor if you use it correctly. The proceedings are typically faster. The rules of evidence are more relaxed, and you can often select an arbitrator who has actual experience in the construction industry. That means the person deciding your case understands construction delays, change orders, AIA contracts, and Florida building code requirements. The downside is that arbitration awards are very difficult to appeal. So your preparation needs to be airtight. You essentially get one shot, make it count. And sometimes the most effective approach is also the most straightforward: direct negotiation. Many construction disputes in Florida are resolved through well-drafted demand letters and strategic settlement discussions before any formal proceedings begins. This is especially true for payment disputes, lien claims, and breach of contract issues. Here's what separates a strong negotiation from a weak one: leverage. In Florida construction disputes, leverage comes from several places. It can come from a properly recorded construction lien under Florida Statute 713. A lien on property creates enormous pressure to settle because it clouds title and blocks refinancing or sale. Leverage can also come from a well-documented claim with expert support. If you can show the other side exactly what the defect is, what it costs to repair, and then your evidence is solid, they are far more likely to negotiate seriously. And here's a practical tip. Always consider the economics from the other side's perspective. If it costs them more to fight than to settle, that's your leverage. Put that calculation front and center in every negotiation. Now, I'm not saying you should never go to trial. There are construction disputes where trial is the only option. When the other side refuses to negotiate in good faith, when the amounts are so large that compromise is not possible, where there are fraud or bad faith claims that demand a public resolution. But those cases are the exception, not the rule. The reality is that settlement through pre-suit negotiation, mediation, or arbitration almost always produces a better outcome than trial. You save time, you save money, and you maintain privacy. And most importantly, you control the result. At trial, you hand that control to a judge or a jury who may not understand the first thing about Florida construction law. So if you're facing a construction dispute in Florida right now, remember this. You have options. You do not have to go to trial to win. Use the Chapter 558 pre-suit process and prepare aggressively for mediation. Understand your arbitration rights and leverage every tool Florida law gives you. Now, if you found this video helpful, hit that like button right now and subscribe to my channel so you get notified every time I release a new video on Florida business law, construction disputes, and protecting your interests. I'm Santiago Cueto, your Florida business attorney. Be sure to watch more of my videos right here.